to see you today.
Hi, Judge Corpening.
This is Emily. Just a notification to all. I got the word that we're live now.
Okey-doke. Hey, everyone. This is Don Bridges. Good to see y'all. Okay, I'm just testing. You all can hear me, right?
Yes, sir.
Yes.
Yes, sir. Great. All right. Good afternoon, everyone. The time is 2:30. Welcome to the June 11th, 2020 meeting of the Chief Justice COVID-19 Judicial Branch Task Force. My name is Don Bridges, and together with Judge Jay Corpening, I serve as co-chair for this task force. I am reminding everyone, as we customarily do, that today's meeting is subject to the North Carolina open meeting laws, and that today's meeting is being live streamed to allow access by members of the public and the media. Because not everyone who is joining the meeting has video access, please identify yourselves when speaking so that we can know who is speaking at any given time. At this time, I will call upon Emily Mehta for a roll call for today's attendance.
Judge Bridges is here. Judge Corpening is also here. Mr. West, District Attorney West.
I'm here, yes.
District Attorney Evans.
Here.
Clerk Johnson.
Here.
Clerk Chingary. Clerk Chingary. I'll come back to her. Kinsley Craig. I'm here. Kelly Myers.
Here.
Jennifer Harjo. Jennifer Harjo. Mr. McCabe.
Here. Sorry.
It's all right. Mr. Harrison.
Here.
Mr. Weed.
Here.
Mr. Keister.
Here.
And I'll circle back. Clerk Shingari? Not yet present. Jennifer Harjo?
Present.
Jennifer Harjo is present. Clerk Shingari is not yet present. And as Danielle mentioned on the email, Mr. Cheek is unable to attend, and Judge Vincent and Judge Sermon will be late. They have hearings, but I will make a note when they join. And also, we'll keep an eye out for Clerk Shingari.
Thank you, Emily. We will proceed next with consideration of the minutes from the June 4th meeting. Copies of those minutes have been circulated to task force members. Are there any requested additions or corrections to those minutes? If not, is there a motion that those minutes be approved as circulated?
This is Wade Harrison, and I move that the minutes be approved as circulated.
Thank you, Mr. Harrison. Is there a second?
This is Robert Evans. I second.
Thank you, Mr. Evans. All right, at this time, please entertain a roll call vote for the approval of minutes from the June 4th meeting.
Judge Bridges?
I vote yes.
Judge Corpening?
I vote yes.
District Attorney West?
I vote yes.
District Attorney Evans?
Yes.
Clerk Johnson?
Yes.
Kinsley Craig? Kinsley? Kinsley Craig, can you hear us? I'll come back. Kelly Myers? Jennifer Harjo?
Yes.
Mr. McCabe?
Yes.
Mr. Harrison?
Yes.
Mr. Weed?
Yes.
Mr. Keister?
Yes.
I see Clerk Chingari has joined. Clerk Chingari, do you have a vote on the motion to approve last week's minutes?
I vote yes.
And Kinsley Craig? Kinsley, can you hear us?
I can now. I had to disconnect and then reconnect. I'm having some issues. I'm sorry.
No problem. Do you have a vote on the motion to approve the minutes from last week's meeting?
I approve.
That is everyone who was present. Judge Bridges.
Thank you. Those minutes will stand approved. The next item on the agenda is item number 3, an update from the virus fatigue working group. I believe that Jim Drennan has that report. Jim?
Can you hear me?
Yes.
Oh, okay, good. Thank you. We are ready for the product to be distributed. We finished it yesterday, actually, the main product. And so we're very proud of it, and we hope that you all will take a look at it and use it in whatever ways you can with the people that you work with and yourselves. The report's basically the same as last week. We have a video and a large document and then 2 one-page documents. The heart of it is the larger document, which was beautifully put together by the AOC communications staff after we gave them the information. So that in terms of process, the information is now in the hands of this task force, but also in the hands of the Chief Justice and McKinley Wooten, and they have agreed to distribute it over their signatures working through the AOC communications office to everybody in the system. As soon as that is done, the anticipation is that it will be available to other groups who might want to use it or take a look at it, bar groups and other similar kinds of groups. The communication office at the AOC has those ties and connections, and we've talked to them about making sure that the Bar Association and other groups have access to these materials should they want to use them. So I don't think I have anything else to say. We made a slight edit to the document to basically reflect the increased stress that the events of the last 3 weeks, or depending on how you look at it, the events of the last decades or centuries have created for many people who work in the system. And so there's a explicit reference to that in the materials, but everybody's stressed, and the document basically builds on that idea. But it was, so that was the only small edit we made. And so I think you'll find it to be a useful document. We certainly hope so, and hope it is helpful to people. So be glad to answer any questions. But that's, again, wonderful group to work with. I wouldn't hear whether Judge Vincent is on this group. If she is, she was on the committee, and Lisa Chingari was on it, Marsha Johnson and Kinsley Craig, people who are on the task force. And then there were some people from AOC who were great as well. So, and 2 outside folks, an attorney from Charlotte and a stress resilience professional from New Hanover County. So any questions, or I guess you all will get to, I mean, I think you've seen working drafts. The draft you'll see is very, very similar to what you've seen already, but hope you'll take a look at it when you get the final report.
Thank you, Jim, for that report. This is Don Bridges again. Do we have any questions for Professor Drennan about the work of the Virus Fatigue Committee?
I said one other comment. I mean, when we started this, we were in the middle of a dreadful medical problem. And we still are fighting that dreadful medical problem. Since then, we've had an entirely different national crisis emerge in terms of our awareness of the way many, many people view the justice system, triggered by the tragic events in Minnesota. But that was just a beginning of people to think about experiences they've had. And ways that people have looked at the justice system. And so I think this couldn't come at a more important time, because those twin crises sort of are connected to each other. They build on each other. They make the feelings people have working in the justice system multiplied by the fact that the 2 crises sort of feed on each other in some ways. So it's an opportune time. It's a needed thing. So,
thank you, sir. And again, many thanks to Jim Drennan and every member of this committee, this working group, for this outstanding piece of work. Personally, I am proud of all of the work that this task force has done, but I am as proud of this piece of work from this group of folks as anything else that we have done. And as I said a few meetings back, there are so many reports from so many different statewide task forces, but I believe this is one of those elements that our report does not share with very many others. This is one of the things that really makes our work unique, is our consideration of this particular problem. And I think this is something that all of us can be very proud of. And we really appreciate not only the hard work you put into it, but the creativeness And this is really outstanding. So thank you very much.
It took a village, but thank you. Yes.
So at this time, I'll hand the gavel off to Judge Corpening to lead us in discussion of the next few items on the agenda.
Thank you, Judge Bridges. This is Jay Corpening. I'll also echo Judge Bridges' comments in appreciation of the work done by the Virus Fatigue Committee. The work product is fabulous and incredibly timely. So thanks, Jim, for your leadership on that. We're going to move to number 4 on the agenda, intermediate and long-term recommendations from our both from our committees and from some of the other work we're doing. And we'll start with an updated report from Best Safety Practices Working Group chaired by Kelly Myers. So at this point, I'll recognize Kelly for an update.
Thank you, Judge Corpening. Good afternoon, everybody. You should have received earlier today, probably around 11 or 11:30, the draft document that we asked Danielle to distribute to the task force. And since that time, our group has met to discuss particularly some of the issues that are raised in that document. And so I want to briefly walk you through that without reading, obviously, the whole report for you, and then open the discussion up to members of our working group to express and explain some of their concerns. So, the objectives of our working group are to make safety recommendations that are evidence-based and also appropriate for the courts. And so as far as evidence-based safety recommendations, we have relied heavily upon our public health advisors, and they have been fantastic. They joined our quick emergency 1:30 WebEx today and helped walk us through some of this. And the overall point that needs to be made regarding these evidence-based safety recommendations are that public health does not believe that in-person jury trials should occur unless safety precautions are in place, period. Number 2 is the appropriate for the courts piece of our role. And as you saw, we tried to highlight in yellow areas where concerns were raised regarding either practical implementation, such as difficulty hearing and capturing the record by clerks or court reporters when people are wearing masks in court, and also constitutional concerns, such as the confrontation clause. This document is divided into 2 parts. The first part is what occurs really before jury selection and trial. So all of the pieces that go into your jury pool and how many people you're going to call and where you call them and where your jury assembly room is going to be and badges and masks and all those pieces that go into it. And then the second part is really proceedings in the courtroom. Because Judge Bridges and Judge Corpening had indicated that the in-person proceeding safety recommendations from our prior report would be included as Appendix A to this report, we tried to not repeat any of those recommendations and focus solely on recommendations in the courtroom that were focused on jury trials and jury proceedings. So the first piece on page 2, I wanted to point out on page 2 under number 10, the comments that we have there that are highlighted will actually need to be moved and discussed under the jury trial section, what goes on in the courtroom. When we talked our call at 1:30, we absolutely reached a consensus regarding the wearing of masks and face coverings in jury assembly areas. So these concerns that you see here on page 10 really should fall under the second section and can be discussed there. And then on page 4 is really where there is not necessarily a true consensus. And this is where the jury trial piece begins. So we included language here that was taken from some federal guidance regarding jury trials. To note that the presiding judicial official will need to weigh the rights of the defendant against the health and safety of everyone in a courtroom. This language does say weighed against the health and safety of jurors, because we were trying to focus this section just on jury trials. However, the health and safety of everyone in that courtroom should be weighed against the rights of the defendant. So the section under here, I would propose that we sort of rework it to clearly set out those two interests and give the judicial officials information so that they can weigh those two options and make the decision that's best under the facts that are before him or her. On that note, unless there are any overall general questions, then I would ask Ms. Harjo if she wants to lead off discussing some of the constitutional concerns and the confrontation clause that she has brought up regarding the recommendations that masks be worn.
All right. Thank you. Then with Judge Bridges, with your permission, this is Jennifer Harjo. So I have been experiencing some court hearings. I've had court hearings with face coverings or masks being worn by lawyers or other persons in the courtroom. And I think it is absolutely impossible to have a jury trial with that type of face covering. I mean, first of all, I think I put in my email to Kelly that, jury trials, criminal jury trials are just different than anything else. They are a constitutional protection that we provide for our clients. And there are also protections that have evolved. And the manner in which we conduct trials is not just a science in a sense. I think I mentioned it's a science and an art. There are so many complexities that give rise to the attorney presenting on behalf of the defendant a fair trial that we need to see the jurors' faces. We need the jurors to be able to see the lawyers' faces, to see the witnesses' faces, to make decisions about whether or not a person is credible or whether or not there is something else, another meaning behind the words that might be expressed. And that just can't be done with wearing a mask. Even talking about jurors wearing them, but everybody else in the courtroom not wearing them. That means the jurors are going to have their face covered and be terribly uncomfortable for a significant period of a time every day. I have yet to see, quite frankly, any judges wear the mask during the course of a day in court right now, and we're not in court all day. I've seen a lot of lawyers refuse to. I myself wear them, but then I have to take it off when I'm speaking with the judge because I found that it's just not possible to be clear wearing that type of face covering. It makes it difficult for each other for one another, between the lawyers and the judge, to hear or understand. I've had a judge ask a person to take it off, a defendant to take it off, because they couldn't understand what was being said. So I think to expect that we could have a jury trial with any of the participants wearing face coverings is, in addition to the connotation it might provide to the individuals that are participating in the trial, especially, and I'm just going to be concerned because I'm talking from the defense perspective, from the defense lawyer to the defendant. I think those connotations are harmful, but it's not possible. And I think it, as well, is very difficult and impossible to expect that we can have a fair jury trial for the defendant if the jurors are wearing the mask. First of all, they're going to be uncomfortable. It's going to be difficult for them to concentrate on what's going on, but it also may interfere with the lawyer's ability to participate in the trial because maybe we're presenting evidence. And oftentimes we look at jurors. We look at jurors to see what is the perception that we believe that the jurors may have to a piece of evidence. And sometimes facial expressions will indicate that somebody is confused or they don't understand or maybe they can't hear. And that leads the lawyer to change the way that they're presenting the evidence and do something a little bit different. And I think we are interfering with that ability to conduct a trial if we try to do these trials with masks. Plexiglass leaves some of the same problems, and some of the same problems with the plexiglass are that, first of all, there's a glare. I specifically noted when I was in the courtroom the other day about the plexiglass that had been put up in our particular courtroom in our Superior Court. And I noticed, depending on where one is sitting, there's a glare. And in this particular case, there was no plexiglass in front of myself or in front of the district attorney. We're just talking about in front of the judge or in front of the witness stand or the court reporter or the clerk. And then depending on how it's, how it's constructed, at least in the courtroom where I was, there's a giant barrier at the bottom of the plexiglass in front of the witness. So depending on where the witness is standing, the barrier is going to appear somewhere in the face or the body of the witness. So I don't think plexiglass is the answer either. And in speaking with the health officials a few minutes ago, they were concerned that being in a room for a long period of time with anybody not wearing a mask was going to cause or create a safety concern. And plexiglass carried the same problems because being in the same room in a confined area with the particles of air being able to be distributed over and above the plexiglass or under it it creates, as they called, a spectrum of safety. So safety would be at its best when everybody is wearing facial coverings, and the spectrum gets moves as we remove facial coverings for certain parties or remove them altogether with plexiglass. So the answer, when asked, what is the answer? And the answer I have is wait. I think we just wait until it can be done safely and can be done with the same consideration to the defendant, to give the defendant the constitutional protections the defendant is entitled to have. If a defendant wants to waive those constitutional protections, they have a right to, and they can choose to have bench trials. They can choose to ask the court if it's feasible safely for everyone else to have a trial with some type of facial covering or plexiglass or some other provisions that will make at least people safe, even if it infringes upon the defendant's constitutional rights. I think the defendant should be entitled to do that as well. But until we can assure that trials can be had to the persons that are accused, not only in a safe manner, but in a fair manner, protecting their interests, I think we just wait. And one of the things that Jim Drennan said a few minutes ago, he said this crisis, the more recent crisis, it feeds on the COVID crisis because we're all in the judicial system. They kind of feed on one another. And I think that's true. And I think now is the time not to take action which might impede on constitutional rights of defendants to get a fair trial. And if they just have to wait, they just have to wait. And that would be my opinion on the matter. And I believe that is the opinion or the suggestion of the defense bar as a whole.
Right. Thank you, Jennifer. This is Jay Corpening. Kelly, as chair of this committee, would it be your preference that you work through the rest of the report or go ahead and take comments from others about this section right now?
We can start at the beginning if you would like to. I focused on this section because I do think it may take a little more time to work through this section, and the others we probably can reach a consensus on pretty quickly. And I'd also, if any of our public health officials are listening or available to offer, I would ask that they do so as well, if that's okay, Judge Corpening.
Absolutely. So why don't we go ahead and take some, have a definite interest in this issue and either have this similar concerns with Ms. Harjo or other thoughts on the matter. First, I'll invite any of our other criminal defense lawyers that are on our task force to offer any other comments that they have about this section.
This is Patrick Weed. I don't have anything specific right now to add to what Ms. Harjo said, but do have a question for her, Ms. Myers, or somebody on that group. My question is, did the public health officials indicate whether their advice about wearing masks at all times would continue until there is a vaccine or effective treatment, or is there a sense that that advice is going to change, if the situation were to improve over the next few months, which of course right now it's not, it's getting worse in North Carolina, not better. But was there any feedback from health officials about when the advice or how long the advice may last?
There was not.
Okay, thanks.
Anything else from defense perspective?
Not from me right now. This is Patrick. Thank you, Your Honor.
Thank you. Then let's move to District Attorney Billy West. Mr. West, happy to hear from you with any concerns you have about this issue.
I am going to yield to Mr. Evans on this. He and I spoke earlier, and we both spent some time on it, but he spent a little bit more time than I have. So I'm going to yield to him for any for kind of stating our position, and then I may jump in at the conclusion or everything else. But he and I talked about that earlier. I'm going to let him lead off on this time at this time.
All right, thank you, Mr. West. Mr. Evans?
This is Robert Evans, I guess. At this point in the agenda, if I understand Ms. Harjo's opposition, the conference would take the position that we are in favor of resuming jury trials as soon as reasonably possible, subject to the best available safety advice that we can recommend to the Chief Justice. I think the rest of my comments will probably wait until we get to the jury trial section of the agenda.
Thank you, Mr. Evans.
And I would just echo that, if I could, Judge. That's kind of what I was thinking as well. A lot of these safety best practices are very good, and I think ours are a little bit more in the weeds of the jury trial resumption. So I think we'll kind of wait until a little bit later on that.
From defense perspective. So this is Jay Corpening. Someone just spoke and I didn't understand what was said or who said it. If you'll try again.
Judge, I'm sorry. This is Jennifer Harjo. I'm having technical difficulties here, so I think that was just my computer. I think that's just my computer.
All right. Other members of the task force or that want to weigh in on this issue within this section of the report from Kelly Myers' committee?
This is Marcia Johnson. One thing that I would like to mention briefly is that the clerks of court are the official record keepers, and it is going to be somewhat problematic for the clerks to hear when there are masks worn. I was in court yesterday, and I actually take notes for the Veterans Treatment Court, as well as I had a criminal clerk in the court doing a recording. And my clerk had to ask on 3 different occasions, what did the assistant district attorney say? Because she could not understand because he had a mask and a very deep voice. And the judge had to state what the district attorney had said. And there were times that when the defendant was talking and he had a mask, I could not understand him at all. So it's not a volume problem, it's that the mask muffle the voice. And so from the clerk's perspective, there may be some problems with understanding what is being said. And I think that the court reporters are probably going to have the same issues with that. So I just want to mention that's a concern of the clerks if it's required that everyone that actually will be speaking wears those masks. That's it.
Thank you, Clerk Johnson. Concerns from other members of the task force?
Judge Corpening, this is JD Keister from the civil side of things. The folks that I've been talking to share a similar concern on the active participants in a trial, of not having lawyers or witnesses or even jury members during the jury selection process wearing a mask. I have to defer to the health experts beyond that in terms of our group didn't really have an issue with jurors wearing masks during the course of the trial when they are not speaking. But if that does not, if the risk is still out there, we certainly understand that.
Thank you, Mr. Keister. Concerns from other members of the task force on this issue?
Your Honor, this is John McCabe. I would echo what Mr. Keister said, that the concerns from the civil defense bar are the same as the plaintiff's bar has the same concerns that the civil defense bar would have about masks being worn at particular times, particularly with witnesses, lawyers, and jurors during voir dire.
Right. Thank you, Mr. McCabe. Other comments from other members of the task force?
This is Wade Harrison. I just was curious as to whether or not the safety experts addressed some of the issues raised about spending longer durations of time within a courtroom where everyone doesn't wear a mask. Because at least in our county, in Alamance County, some people wear masks and some people don't wear masks. So it's I'm just curious as to whether there's any science-based information that could inform the Chief Justice about whether masks should be strictly required or not strictly required, whether there's any significant increase in risk the longer you spend in an area where there could be someone who is infected by the virus but not is asymptomatic.
Thank you.
This is Kelly Myers. Judge Corpening, if I think it might be useful for the task force if any of our advisors from Department of from DHHS are on and could speak to this. They gave us some really great information during our 1:30 call, and rather than me try to paraphrase, it may be better if they can explain really about the continuum of protections and risks, and then about specific time spent in a closed space, such as a jury trial.
Thank you, Kelly. This is Jay Corpening. Do we have any of our public health partners on the call that would be willing to weigh in on this?
I don't believe we do. I think Dr. Wilson was the only one that would have received the invite, and I do not see her on here.
All right, thank you. Other comments from members of the task force on this section?
Judge Corpening, this is Don Bridges. I would like to weigh in with a comment or two and a question or two at the appropriate time, but I want to give everyone a chance to speak before I do.
Thank you, Judge Bridges. Any other members of the task force that want to weigh in on this?
This is Jennifer Harjo, and I guess I want to try to answer the question as best I can from what I heard our public health persons tell us just a few minutes ago. But as I understand, the increased danger, I guess they didn't use that word danger, but it's a spectrum. So it's safest for everybody to wear masks. And as one person or more take it off, then that's just a spectrum of safety. It becomes less and less safe. And the same with the time. Shorter period of time in a confined area is safer than a longer period of time. And our health expert did also say that it did depend upon the air circulation as well. That was a factor as well. I think all of those things they considered factors. I do not believe our health experts told us that there was any specific date when they felt that masks would not be recommended. I think we just don't know that, but I didn't hear that information, so I'm not sure about that information.
Thank you, Ms. Harjo. This is Jay Corpening again. Anyone else from the task force with thoughts on this particular section?
This is Patrick Weed. One additional thought I have with some of the concerns that Ms. Harjo raised. I know we have talked a lot about the idea that there's not a one-size-fits-all for different procedural issues throughout the state, but I think in the criminal context, this issue is getting closer to needing a one-size-fits-all approach such that we don't begin to have a large number of potential appellate issues if some counties are doing trials and mask and confrontation issues in one way and other counties are doing them in a different way. So just wanted to add that thought as well.
Thank you. Thank you, Mr. Weed. This is Jay Corpening again. Any other comments from anyone else on the task force before Judge Bridges weighs in? Judge Bridges?
Yes, sir. First of all, I would like to ask for a little more clarification and give Ms. Harjo an opportunity to clarify what her request is in this regard. What I have heard is that because of these safety concerns, that so long as masks are recommended for safety purposes and because of the potential interference by mask with the opportunity for a fair trial, that no criminal trial take place except in those instances in which a defendant chose to waive his or her protection and to proceed with a criminal trial. I want to make sure I've understood. Is that the request or is that the position?
That is the position, yes, sir.
So in those cases in which a criminal defendant, for example, chose to waive that protection, or even further, in cases in which a criminal defendant may choose to file a motion for a speedy trial, not only consenting to go to trial, but in effect demanding to go to trial, then what would happen?
I think in that circumstance, we have to use the recommendations that we have, our best safety practices, and conduct a trial under those circumstances to make it safe for the jurors and for all other participants in the courtroom. And I'm sorry, I forgot to announce myself. This is Jennifer Harju again. So I think in that sense, we might have to use some of these other alternative safety protections, such as requiring everybody to wear a mask, or such as having the plexiglass, or such as perhaps even portions of it by remotely, portions of the trial video by some type of remote proceeding. I think if the defendant wants to have a trial, and I do believe there are going to be some that are insistent upon having their cases resolved, and I think they may be willing to do so to the extent that we might have to have some protections or procedures that are not necessarily what have been utilized in the past. And I think if they want it, they get it.
Well, I'm sure that, Ms. Harjo, I'm sure you see where I'm headed with this question, and I think probably most other people do as well. And I'm certainly not trying to cross-examine you, but the concern I have out of that request is it almost is saying to me that it's up to the defendant and the defendant alone to make that decision, because with the stroke of one brush, we say that no defendant should be forced to submit to a trial that might not be safe for him or her, or might present some obstacles to a fair trial to him or her. But yet, if a defendant chose to file a motion for speedy trial, do we then say to witnesses on the other side, or jurors for that matter, no, you're going to be brought into the courtroom and you're going to be subjected to all these same conditions that other criminal defendants chose not to subject themselves to, so that this defendant can receive an immediate trial. And to me, that is a matter of concern, that we let one person determine when to proceed or when not to proceed. You see where I'm coming from on that?
Well, yes, sir. Again, this is Jennifer. And I do and I don't, because the one person in the courtroom in that specific circumstance, and when we're talking about a criminal defendant, that is the defendant that has certain constitutional protections and certain constitutional rights that are in place, that have been placed by our Constitution, and again, as they've evolved through state law and through case law. So I think those protections are there, and we have developed these protections over a number of years. And so I just think it's different because we're talking about being able to protect the defendant's constitutional rights versus, and maybe not versus the safety, because I think we have to assure everybody's safety, number one. And I think we can have trials and have proceedings that place these barriers between the litigants and between perhaps even jurors in certain circumstances. And maybe in certain cases it would be appropriate. But when we're talking about a criminal defendant that perhaps is looking at spending maybe the rest of their life in prison, or perhaps having their life taken from them, I think at that point in time, if I'm asking, well, let's just wait until perhaps we don't have to wear a mask, or have jurors wear masks, or the litigants, I don't think that is an unreasonable request at this time. I don't know how long the wait is, quite frankly. And maybe it's an assessment that we have to look at again months down the road. But I think if we're talking about August, September, October, November, or 2020, I don't think it's an unrealistic request to say, let's wait so that the defendant can have the type of trial that the defendant expects, that our state and our government has provided to the defendant all these years. I mean, I just think that that's not an unusual request. And I don't think that's making the defendant or the accused have all of the power. I think it's just providing them the protections that they're entitled to.
Well, the reason, and this is Don Bridges again, the reason I pose the question in that manner, and again, I'm not trying to cross-examine you. Please don't feel like that you're under attack.
I know.
But as has been pointed out to us in previous meetings by the members of the Conference of District Attorneys, especially in North Carolina, the defendant's not the only person in the courtroom who has constitutional rights pertaining to that trial. We have recently enacted amendments to the North Carolina Constitution that provide to certain victims constitutional rights as well. And so it's not just the defendant who has constitutional protections that are associated with the trial. And I'm certainly not going further with that. That's all I wanted to ask about that, and that's all I wanted to say about that point. The second concern I have about the direction in which our discussion is headed right now is I would like to ask all members of the task force to remember what we're talking about right now. We're talking about a report from the Best Safety Practices Committee. We're not talking about the plan for resumption of jury trials. And somehow we've chased a rabbit here. The purpose of Ms. Meyer's report is to present to this task force the work of the best safety practices working group to inform us what the recommended best safety practices are that have been arrived upon in consultation with public health authorities who are the experts with regard to this pandemic and with regard to the spread of the virus. We're not, at this point in time, we're not talking about policy considerations. Now, I understand Ms. Harjo's position, and I understand everyone has a right to express an opinion with regard to the resumption of jury trials. But here we are talking about waiting about the resumption of jury trials rather than talking about a discussion of what the best safety practices actually are. And I think that is the role of this working group, not for this working group to decide on whether or not, policy considerations with regard to jury trials. And that's actually another item on the agenda. And so I hope that we can be mindful of that, and I hope that we can adopt a final report from this working group that will carry out that mission of defining for us, in consultation with the health officials, what the actual best safety practices are. And if there's disagreement about that, and Ms. Myers and I have spoken on this point a number of times, and I think she's worked very hard to do this, on the points on which it's pretty clear what the best safety practices are, that those practices be expressed in that manner. In areas in which there is disagreement, that disagreement be noted, so that our work product does not mislead or misinform anyone. We simply express the best information that we have been able to get from the health officials. So I hope that we can stay on task and actually carry out what this working group was charged with doing, rather than getting into areas that are actually not necessarily part of the mission of this working group. And that's all I'll say about that. Judge Corpening.
Thank you, Judge Bridges. This is Jay Corpening. That's a great segue to go back to Kelly Myers. And Kelly, at this point, I'll ask you to review the rest of this report and make any comments or points you'd like to make.
Yes, sir. Thank you, Judge Corpening. Beyond the few questions that were asked today that we did not have answers to, I mean, the safety recommendations that are contained herein, I believe, are ready to go. I would like to add a section on plexiglass that the little bit of information we did receive today, and then some of the specific information about time spent in a room together. But other than that, unless the task force has additional questions or other safety recommendations, I think we can edit this quickly and it's ready to go.
Thank you, Kelly. This is Jay Corpening again. So let me say at this point that I support the message that Judge Bridges has just delivered, that the role of this committee is about best safety practices. And then those best safety practices will be taken into consideration as part of our issue of resumption of jury trials. And certainly that's a place where competing concerns will be delivered to the Chief Justice. So what's the will of the group in terms of adopting the report of the Best Safety Practices Committee with respect to health and safety guidance for the Chief Justice based on consultation with public health?
Judge Corpening, this is Kelly Myers. I would suggest that we, DeShield and I can rework the second section on jury trials to really focus on the safety recommendations and noting if there are any inconsistencies in those safety recommendations, and get a final version out to the task force if they want to vote on that by email.
Right. I'm open to that, Judge Bridges. I'm open to either that or having that done, redistributed for thoughts from anyone and a vote next week when we meet again.
This is Wade Harrison again. Would it be possible to have our public health advisor just do a separate appendix and set out the information that is the basis for the recommendations, so that there's some sort of linear rationale for the recommendations based upon the science?
This is Jay Corpening. Mr. Harrison, we can make that request through Kelly Myers and her committee. We can make that request. They've certainly gotten some guidance from public health, and that's a good suggestion. Right. Thank you, Judge Bridges. Any preference between this being circulated for email vote after it's revised or coming back before us next Thursday?
I have no preference.
Right, then Kelly, if you will revise that section, if you can ask public health officials for the kind of information that Mr. Harrison has requested to attach as an appendix, then we can circulate that for an email vote early next week, if that meets your timeline, Kelly.
Yes, sir.
Right, thank you.
Thank you.
Right, then moving to Technology and Innovation Working Group, I'll recognize Senior Resident Superior Court Judge Chuck Henry.
Thank you, Judge Corpening. I believe at your last meeting, we submitted our intermediate recommendations, and you had previously received our immediate recommendations for your consideration. We have since submitted to you our recommendations related to jury trials, many of which had been incorporated in the recommendation on the resumption of jury trials, but we can answer any questions with you, which the task force may have with regards to that. I believe several of the work group members are also task force members. We have compiled our list of long-term recommendations, which have been reduced to final form and are in the process of being voted on. And we should have that final vote for you by the end of the business day on Monday. Is my anticipation that it'll be approved as written, but we're still, everyone will have an opportunity to have some input as well as a final vote. So a lot of what we talked about may be subject to discussion as to the resumption of jury trials. So I'll return it back to you or any member of the work group for any questions or comments that you may have about our written recommendations that have already been submitted in. Any questions about the recommendations that probably will be shortly submitted to you. We have no further meetings scheduled, but at any time we could be reconvened for purposes of answering specific questions or address certain recommendations. I'll take this opportunity to thank all the participants. They're all very valuable We had a very open discussion. Some really, I believe, valuable recommendations were reached for the Chief Justice's consideration and your consideration. I'll commend the AOC staffing that helped us. As I said before, my district was subject to Hurricane Florence doing extensive damage to our court facilities, and I was overwhelmed by how AOC helped us recover. And the staff again has met that high bar in their help with our work group. So with that, I'll return it to you, Judge Corpening, for any questions or comments.
Thank you, Judge Henry. Any members of the committee that want to add any comments? Right, then questions from the group, and I would suggest that that any questions or comments related to this committee's recommendations on jury trial, resumption of jury trials, be held for the later agenda item. But any other comments or suggestions? All right, hearing none, I've got a question from Danielle and maybe for Emily. I'm going back through the minutes of last week's meeting, and I don't recall whether we as a task force approved the intermediate recommendations last week or not.
Your Honor, I wrote those minutes and I can't remember either. I'm not sure you ever did, as a full group, formally approve them, because we said we were going to hold those for the second report. So it may be worth holding a formal vote on that, unless someone is remembering that happened. Or I can check the minutes while you all proceed with further discussion.
This is Jay Corpening. I don't see it in the minutes from last week, and that intermediate report does include recommendations on the resumption of jury trials. Perhaps Judge Henry, what I'll ask, and I'll ask Judge Bridges to weigh in on this as well, is that on your intermediate report, you create a Part A and a Part B, with Part A being your Technology Innovation Working Group intermediate recommendations exclusive of resumption of jury trials, and that then you have a second document that relates specifically to jury trials, and it may be formatted that way as it is.
Judge Henry, my recommendation was our intermediate recommendations was in a final form, had been approved by everybody, and I believe that had been submitted to you by your last meeting. I think it was last Thursday. I kind of held back the recommendations as to the jury trials for, I guess, a final review of the group, and then we submitted them to you, and I think a lot of your recommendations were adopted or included in the resumption of jury trial. So whether there's a formal acceptance of them, I can't speak one way or the other.
Right. Thank you. Judge Bridges, your thoughts on proceeding with this?
My thought is that out of an abundance of caution, why don't we entertain a motion to either approve or ratify the approval of the intermediate recommendations by the Technology and Innovations Committee, with the exception of those provisions pertaining to the resumption of jury trials, which we can then address in the jury trial item that's coming up next.
I so move. This is Wade Harrison.
This is Patrick Weed. I second.
Motion's been made by Mr. Harrison, second by Mr. Weed. This is Jay Corpening again. Any discussion on approval of the intermediate recommendations made by the Technology and Innovation Working Group, exclusive of the resumption of jury trial recommendations? Any discussion? Hearing none, Emily, if you'll do a roll call vote for approval of the Technology and Innovation Working Group intermediate recommendations exclusive of the resuming jury trials.
Judge Bridges,
I vote yes.
Judge Corpening,
I vote yes.
I see Judge Vincent has joined us now. Judge Vincent?
Excuse me, I vote yes.
District Attorney West?
I vote yes.
District Attorney Evans?
Yes.
Clerk Johnson?
Yes.
Clerk Shingari?
Yes.
Kinsley Craig?
I vote yes.
Kelly Myers?
Yes.
Jennifer Harjo?
Yes.
Mr. McCabe?
Yes.
Mr. Harrison?
Yes.
Mr. Weed?
Yes.
Mr. Keister?
Yes.
And I don't believe Judge Sermons has joined us yet, so that is everyone.
All right, thank you, Emily. The Technology and Innovation Working Group intermediate recommendations are approved. And let me also say thank you to both of the committees that have just submitted reports for all of your work. I was on a call with all the Chief District Court judges right before getting on this call, and I shared with them that although we meet once a week, the work of this task force is daily and sometimes nightly. So thank you for all your work. With that, Judge Bridges, I'll turn it back to you for discussion on resumption of jury trials.
Thank you, Judge Corpening. First of all, I want to say a few words about where I understand we now are with respect to our work pertaining to eventual resumption of jury trials. As you all will recall, the Chief Justice has directed us to present to her a plan for the resumption of jury trials. And that's what we have been working on now for, I don't know, a month or so. As you all also know, this has at times, and frankly more times than not, presented a very difficult topic for us. As we say in the draft of the report itself, it is one of, if not the most difficult challenges about ramping back up toward full operations. So we all know that. At the time of our last meeting, I believe we did certain things. One, we decided to eliminate from our recommendation to the Chief Justice any specific date on which jury trials are recommended to be resumed, and that we would leave that entirely to the Chief Justice based upon her assessment of what health conditions existed at any given time. And we will leave that decision entirely up to her. So I believe that our proposal is now that whatever report we submit to her, we are not going to recommend any specific date on which jury trials should resume in this state, but rather leave that to her as part of her call. Secondly, as you all will recall, at the time of our last meeting, we received a report from the Technology and Innovations Working Group, in which, and that report was described to some extent as a three-legged stool to try and craft a mechanism upon which jury trials could resume after certain safety considerations were taken into account. One of the concerns that was expressed was the role of the clerk in that decision-making process. that and you all will recall also that in a previous emergency directive, the Chief Justice has ordered that the senior resident Superior Court judge undertake certain actions, including work toward whatever precautions need to be taken with regard to the resumption of jury trials. It is clear that the Chief Justice intends that the senior resident judge and or the COVID-19 coordinator designated by the senior resident play a very significant role in the crafting of those local plans. So one of the requests from last week's meeting was that the clerk, because of the extent of the responsibilities of the clerk with regard to the summoning and managing of jurors, also be recognized as playing a critical role in that process. So one of the recommendations coming out of the Technology and Innovations Committee was that in formulating that plan, rather than acting alone, that the senior resident judge work in consultation with the clerk, with the elected district attorney, with the public defender in districts in which there is a public defender, and in districts where there is not a public defender, with one or more senior members of the local criminal defense bar, in making the assessments and in formulating the plan. There were a number of other recommendations, and I'll talk about them further in a little bit, but let me make this commentary at this point. What I have attempted to do since the time of last week's meeting is to take that report, those recommendations from the Technology and Innovations Working Group, and to the fullest extent possible to merge those recommendations into the previously existing document, to adopt all of those recommendations and to include those. Now, there are some areas in which the language has departed slightly. I believe that has, in every instance in which we varied the language some from what that working group recommended, I believe that I have done so with the express approval of Judge Henry, and I hope he'll correct me if I'm misspeaking in that regard, and I'm certainly not trying to put him on the spot by saying that or to force him to ratify what I'm saying. Please point out anything that I've said that's not accurate. Some of the recommendations from that working group included we changed the language rather than recommending a date simply to say that the Chief Justice would specify a date as the earliest date on which jury trials would be allowed to resume. We also included the provision that the senior resident work in consultation with the elected clerk, district attorney, public defender, or senior member of the defense bar in formulating the plan, that in keeping with the themes that have been expressed previously by this task force, we included provisions that although the specific case selection of cases for trial would be determined by local officials, that is the senior resident in consultation with those other local stakeholders previously mentioned, that we would recommend that the resumption of jury trials begin with the short and simple trials. Civil trials that are expected to last no more than 1 week, misdemeanor appeals, Class H or I felonies, or as I said, other cases that would be expected to last no more than 1 week. Now, there was talk from the criminal defense bar, there was a request from the criminal defense bar that there be no murder cases no first-degree murder cases, capital or non-capital, before a specified date. The proposed wording on that topic now is, again, a recommendation that no Class B2 or greater jury trial be undertaken during the first 90 days. There's also a provision in here that the local judge, the local senior resident, would have the discretion, depending upon local health conditions, even after specification of that earliest date on which jury trials could resume, that local judge would have the authority to delay the resumption of jury trials for additional periods of time in the exercise of discretion, or after jury trials are resumed, even to suspend the conduct of jury trials, again, based on local health conditions. Ms. Harjo in particular requested a provision on behalf of the criminal defense bar that jury trials not proceed without the consent of the defendant. One of the things that we included in this draft of this plan would be, again, to suggest to local court officials that they consider a number of factors in determining whether or not particular trials or particular types of trials could proceed. One of the factors that was specifically mentioned in those factors to be considered by local court officials would be the consent or lack thereof by a criminal defendant to the case proceeding to jury trial. So we have indeed included that provision in this language as a factor to be considered by the judge. Now, let me say, by way of, and this was an oversight on my part. Judge Vincent, in particular, requested at our meeting last week that because district court also conducts jury trials, that there be language that would include the district court judges in this decision-making process. I was absolutely certain that in one of my revisions of this draft that I had included that language. And then today, in preparation for today's meeting, I went back and scoured the language of this document, and I learned, to my great embarrassment, that I had failed to do so. That is a complete oversight on my part. It was unintended, and I intended for that language to be in there. The manner in which I thought I had included the language was to include the chief district court judge as one of those stakeholders to be involved in that consultation process in the formulation of the plan. And it is still my intent to include that language in the final draft. Now, since the time of the publication and circulation of this draft, I received communication from Judge Corpening that he had gotten some requests back from his district court judges working group, which again we had requested also as part of this process, concerning the formulation of this plan. And as I understand it, one of those requests was that, in effect, that the district courts be charged with doing the same thing, with formulating their own plan in a manner, in effect, parallel to and consistent with the provisions that are being recommended for the Superior Court to formulate a plan for the resumption of jury trials in the Superior Court. Now, I will offer this by way of comment, not by way of judgment. It seems to me that in this regard, we have two options. We could proceed in that manner in which, in effect, we charge the senior resident Superior Court judge with going forward under this framework that I have described, and at the same time charge the chief district court judge with going forward under the same or similar framework with regard to the district court, in which instance we would then have parallel plans which may be the same or may differ somewhat between each other from district to district. Or we could simply recommend one plan to be submitted from each judicial district that would apply to both superior and district court, being careful that we sufficiently include the district court in the decision-making process so that it would be appropriate to district court when it is adopted to apply both to the superior and district court. It seems to me that it could be workable in either of those ways. Now, I believe I have addressed all of the significant changes that have been made in today's draft concerning the plan as it differs today from what we had a week ago. The message that I received from this task force 1 week ago was that, and I understand we didn't take a vote on it, but we did go around the table and we received comments from, I believe, everyone that wanted to express a comment on this point. And at least my reading of the message I received from you all, and in effect the marching orders that I was given, was to go back to the drawing board to try and integrate with the previously existing proposed plan the recommendations of the Technology and Innovations Committee. I believe we have now done that. In addition to the redrafting in consultation with Judge Henry, I also took the same matter to the Superior Court Judges Working Group, had it reviewed by them, incorporated some slight tweaks, some recommendations from that group. And so now what I present back to you is a product of those efforts. And I'll be happy to entertain any comments that task force members wish to make about the draft as it currently exists.
Judge, this is Robert Evans. As I recall last week when we discussed this matter, one of the comments I made was that I believe, and I think I speak for the entire Conference of DAs, that we are in favor of and support any and every effort that can be made consistent with best practices to ensure that when jury trials resume, they can be resumed safely, consistent with the best knowledge that we all can muster. When the report was submitted last week from the Technology Committee concerning the resumption of jury trials, there were several issues that the DAs, I believe Mr. West and I had some concern about, and I want to just talk about those for just a second. The primary thing that I think we have concern about is we are all, I think, understanding that in the midst of this crisis, we're going to have to go slow and be very reflective and choosing what cases we bring citizens who are jurors, potential jurors, and witnesses to our courts. The list of items that should be considered and discussed and consulted with among the various constituencies, I think are appropriate. And probably as we move forward, there might be others that are added. The primary concern of the conference is that given the restrictions that we're all going to be under until we get a vaccine or when this virus dissipates, if it does, is the, for lack of a better term, the erosion of our authority under 7A 49.4 to set calendars. And I just want to take a minute because I think that that might sound a little bit more incendiary than I intended, but I want to harken back to comments made by some of my colleagues on this task force last week. I think Ms. Harjo, and then I think today, Mr. Weed mentioned that this virus in North Carolina is getting worse by the day. None of us can predict what's going to happen in months to come, but just in the last couple of weeks, we've seen mass protests in the street where people were not social distancing and not wearing masks. We have our citizens who are shopping and eating in restaurants. And in Wilson County, I recently had to close down a gym owner who, fortunately for me, did agree to close, but he joined a lawsuit against the governor. And the point I'm making is that this committee has worked extremely hard, and I commend everyone to, I think, try to develop a product that's going to give us the best opportunity to protect the public as best we can. But the courts are operating as best we can. We're not going to be operating in a bubble, and we're going to have to deal with citizens, witnesses, defendants, and others who are engaging in these activities that we see every day that unfortunately are, I guess, making the problem worse than better. Having said that, I think that the main issue we have is when you talk about trying simple cases. I think that that is a no-brainer. You talk about trying cases that are not lengthy. I think that is a no-brainer. But this proposed restriction on cases by class, I think, is unnecessary. When you look at how we're going to be structured in our different districts with our Superior Court judges, our COVID coordinators, and our committees, I think this just to suggest to DAs that for the first 90 days or how many ever days that we only try what could be called low-level felonies, whatever that means, and not expand, if we can possibly expand that to more serious work, doesn't really get at the issue, because I think the real issue is not what class of cases that we're going to try, if we try any at all, but the real issue is, as I analyze it, given the risk that we are all going to be dealing with, our jurors, our witnesses, our clerks, all of our court constituencies, the general public, what cases or what type cases are worth bringing to the court system, period, in the short term at least, as opposed to what class of cases. So, for example, I think if I were to sit down with my people and we were to analyze whether we were going to try in the next 60 days a false pretense case where the defendant was out on bail and the amount of money involved was $1,000, my first reaction might be that that case is not worth, even if the defendant doesn't want to plead guilty right now in the short term, that case might not be worth risking the health and safety of jurors and witnesses to bring to a courtroom. On the other hand, at least in my district, there are a whole inventory of homicide cases that are not complex cases in the sense that they're going to take 3, 4, 5 weeks to try. There are cases where the defendant's been incarcerated. For one reason or another, he's not wanting to take a plea that we think is reasonable. There are cases where the discovery process has been completed, all motions have been heard, and these cases, several of them were scheduled before the COVID crisis put us where we are today. And in those cases, I would submit that assuming that we can go through our protocols and assuming that in consultation with the clerks, in consultation with the judges, the sheriffs, and all other parties who are interested, that we can reasonably say that we have adopted a protocol that makes it relatively safe considering all of the factors. These cases are no more difficult to try than the average Class H felony. And so I guess what I'm saying is that when you put the artificial classification on cases that you're saying we shouldn't attempt, I just don't think that, and I think the conference agrees, that that analysis gets us what we want. We want to be in a situation where we are inviting jurors and the public in and doing our best to try cases, at least in the short term, that matter. And I would assume, for example, and I was reading some article where a juror, I think out in the West, was upset because he got called to jury service in the middle of this virus. And it was a case involving the theft of a $20 item at a grocery store. And his question was, why was I brought to the courtroom or courthouse for this trial? So it is our position that we should not be restricted by class of case, but I think type of case, and in that respect, short cases, cases that can be tried relatively quickly, cases that involve low density in the courtroom. For example, the homicide cases that I referenced, most of the time when you get past the Monday gaggle of people in a courtroom, and I understand that we can't have that now, those cases involve 4 or 5 witnesses, maybe an SBI lab person who's going to come down at a specified time, and a pathologist. And they're generally in the jury's hands by Wednesday or Thursday. And generally there are cases where, even though the defendant is not wanting to plead guilty, he's not going to put on any evidence, and he's just going to argue reasonable doubt. So we don't see a difference in that case, assuming that we can go through the protocols as we all agree are necessary. And the run-of-the-mill Class H felony, which sometimes, as you all know, takes much longer than is represented when the judge asks how long is this going to take. One of my colleagues mentioned she was in a district that tried a case about the illegal hunting of ducks that took 2 weeks and involved 20 witnesses. And so the conference doesn't think that restricting cases by class is necessary to get us where we need to get to. I'll stop talking now and invite Mr. West to come in.
Mr. West?
Yeah, I think Mr. Evans has done an excellent job outlining Conference of DA's concerns. I hope you received prior to lunchtime. We had taken the recommendations on the resumptive jury trials and had a couple of edits we suggested that are along the lines of what DA Evans has outlined. But in the spirit of not being long-winded, I would just say that it really comes down to 2, I think, primary objections that we have, and that Mr. Evans has already addressed appropriately. The first would be the classification of which case type can be tried, where we think that language such as a shorter and less demanding jury trials was what we recommended, is our recommended language, would be more appropriate than trying to get into to case types. And also, just that some of the provisions seem to infringe on 7A 49.4, which give the district attorney the obligation of countering cases. And I would assume, and I want Mr. Evans to correct me if he doesn't see this to be the conference's position, that we wouldn't really we would object to any 90-day period where you can't do this or you can't do that. That it would just lay out the task force recommendations for a plan on jury trials, without case classification or without any specific 90-day period, which put which put up any barriers as to what cases you could try. But I think that pretty much summarizes, we had some other, concerns that we highlighted in that document that we sent, but most of them all relate to those 2 or 3 points. But I'd ask Mr. Evans if I missed anything.
No, sir, I don't think you did. I did want to add a couple things. We've talked about capital trials, and I know anything is possible, but I would find it highly unlikely and be shocked if in the short term that a judge anywhere, given what we're facing, would approve the initiation of a capital trial. It would seem to me that given the structure that we're trying to set up as a committee, that would be almost an impossible bar for a overzealous prosecutor to overcome, to come in a courtroom and say that given where we are now, we're going to start a capital trial. So that's not what we're saying. I think I've said this before, but in my district, and I'm assuming this is true in most districts, once we start this process, I cannot believe that there's going to be a situation where if any of my clerks come to me and say, Robert, what you are proposing, we can't do now for reasons of staffing or whatever, that I'm not going to say, okay, we'll try another time. Or if one of my colleagues on the defense bar comes to me and says, would you not consider trying any of my high-level felonies right now, even though you might be able to do that, because I have concerns because I have an underlying condition that unduly exposes me to risk. I guess one of the things that has always, been important to me as a lawyer is the collegiality that we have as a bar. And a lot of the issues that we've discussed recently that one might think might be contentious in certain districts, I just don't see it. So that would be the reason I think that myself and the conference feels like a lot of some of the language that we're talking about that would unduly restrict us in terms of analyzing how a calendar ought to look and what ought to be on it is unnecessary.
Thanks, sir. This is Don Bridges again. First of all, I want to thank Mr. Evans for that clarification about the gaggle of people in the courtroom on Monday morning, because I was just getting ready to interject that if you still got a gaggle of people in court on Monday morning, you haven't been paying attention. So I appreciate you making sure that we knew you've been paying attention on that point and you've eliminated your gaggle of people on Monday morning. Second, I will point out the fact that this current draft specifically makes reference to the statute that's been mentioned, GS 7A-494. That came out of the product of the Superior Court Judges Working Group, that we need to recognize what the actual calendaring authority is. We understand that the district attorney has calendaring authority, and the reason that statute is mentioned and is included in this current draft is to make it clear that it's not the intent of this task force to try and shift or imply that that authority has changed in any way. But as Mr. Evans also so aptly pointed out in some of his last remarks, when he mentioned that if a capital case was scheduled, that there's no judge that would approve that right now. That again points out how that authority actually works. That while the district attorney has the authority to create the calendar, the judge has the ultimate control over whether or not a particular case goes forward on a particular day through the power to grant continuances or even change the order of trial. So there is an interplay. The district attorneys have authority, but that authority is not absolute. The other comment I would make is I hope that everyone is mindful, and I hope everyone pays attention to the fact that every single word that is phrased in this plan talks in terms of recommendations. and not in terms of shall, must, or it will be this way. One of the things that we said from day one in our work on this task force is it is not the job of this task force to issue any sort of mandate or directive to local court officials, but rather to provide a resource and recommendations. That our job is to make recommendations to the Chief Justice and to provide a resource and recommendations to local court officials who ultimately will make all the decisions. And even, in talking in terms of the H&I felonies, the Class B2 or greater felonies, the 90-day period, all of that is couched in terms of recommendations and not in terms of mandates. So the local officials can take that and do with it whatever they choose to do, ultimately within the confines of any emergency directive that the Chief Justice chooses to make. And if the Chief Justice chooses to make a directive that specifies classes of cases or other considerations, then I suppose she has the authority to do that. But we are not attempting through this draft to issue mandates or directives. They are recommendations. Now, with regard to, and the other point, that is a very good point, and I agree with this point made by Mr. Evans, that there are Class H felonies for which trial would take longer than a murder trial. And Judge Henry made this very point in our discussions. He used a similar illustration. He said, for example, he had seen plenty of embezzlement trials that, while they're Class H felonies, could take 2 or 3 weeks to try. And so his recommendation was that these early cases be chosen based on not only the complexity of the trial, but the anticipated length of trial. And we specifically incorporated language suggested by Judge Henry of trials that are projected to take a week or less. Not during the first 90 days, but as the ones that are chosen as those very first trials. Perhaps I need to clarify to you what we were attempting to recommend in that regard. Judge Henry, please feel free to inject anything that I may have misstated or may have overlooked in that regard.
No, I think our main focus was the length of the trial. We don't know how the jurors are going to respond to jury duty over a period of several days. We don't know what may happen if a defendant were to claim illness on the second or third day of trial, throwing the likelihood of concluding it in jeopardy. There's a lot of unknowns, and with the wisdom that the collective wisdom and experience of these groups, we still haven't worked through every possibility. I just thought shorter trials are more likely shorter trials probably do not encompass the higher class felonies. I cannot say I've tried a second-degree murder case or higher in less than a week in a long period of time. So we use that as a rule of thumb. And again, it's going to be local. It's going to be controlled locally. And it's going to be controlled by the cooperation of all the people involved: clerks, DAs, sheriff departments, defense bar, public defenders. It's going to be a cooperative effort, and I think we're all going to work together. So I guess maybe arguing over the exact language of a recommendation somehow after a while becomes less productive. I agree with Judge Bridges. Thank you.
Hey, Don, this is Waylon Sherman.
Yes, sir.
In listening to all this, I certainly understand my good friend Robert Evans' concerns in certain courtrooms, but he knows this doesn't have that in my courtroom. because we talk and listen and work it out. But the way we came up with this language when we started talking about H's and I's or something low level was primarily driven by the fact that we don't know how it's going to work to bring that many people in on Monday morning, or how it's going to work to bring some in on the morning, some in the afternoon, how it's going to work to bring 4 over, 10 over. We just don't know how that's going to work until we do it. And once we do it and we see what's happening, then we can react to it and change things and do it better next week, or we can, change things. So that is primarily the driver. We called it, I don't know, jury trial light or something. I forgot what we called it, Chuck and Don, but just something that we would ease into this jury, knowing that we would have some hiccups in it, possibly. And as far as the 90 days is concerned, I don't really care. I mean, I don't necessarily think that that's important to have a prohibition against anything, because August, September, October. By October, we probably ought to be able to be trying pretty much what we want to if we've had a couple of jury trials, but we're not going to come out with a complicated case that we don't even know how we're going to get the jury picked and how those things are going to work. So I think that was the importance of it. So I would certainly not be opposed to a little bit of wordsmithing, but the intent is try it out first, find out what works, and then get better.
Thank you, Judge Thurman. Yes.
Kelly Myers. I just wanted to add the recommendation of our public health experts is that the exposure risk increases with the amount of time spent in the courtroom. And so that's in our document on page 4, but I wanted to add it because Judge Henry focused really on a lot of the reasons why shorter trials should be the focus at first. And I think our public health experts would also agree.
Thank you, Kelly. And indeed, Judge Henry kept reiterating that very point to us during our working group meeting. And that was a big driving factor behind the recommendation for shorter trials. So are there other comments? What about the criminal defense bar? What do you all say about this?
This is Jennifer Harjo, and I like the recommendations. I do understand one point that Mr. Evans made, and that's that there may be a serious trial that would be very quick. But given that these are recommendations, that could be accommodated by a request of both the defendant and the district attorney. And at the same time, it gives the recommendations of the proposal gives consideration to a lot of the concerns that the defense bar had about the need for investigation and collection of evidence and witnesses and downtime that we've had. And I don't want to call it downtime, but just inability to perform certain tasks for complicated trials due to the danger of being physically present with other individuals. So I think it's good.
This is Patrick Weed. I was also very pleased with the draft, as I mentioned last week. I think that the initial sections that lay out the different interests and concerns of each of the stakeholders is very well done. I believe that number 11 from the defense perspective that we're talking about which cases to focus on initially in the 90 days reflects the concerns not only the clerks indicated that we've heard today from Ms. Myers and what the medical individuals are saying, but it also reflects feedback that I received initially of concerns, as Ms. Harjo just said, from defense attorneys about the ability to prepare. I think for high-level cases, B2 offenses and defendants are potentially looking at decades in prison, if not life prison, for a first-degree murder case. And so I think those cases we need to look not only at the health issues, but also working to ensure adequate preparation time. I can, say personally, I have a client. I do my homicide cases. I have a client in in one county right now where I had to do a phone call visit. The jail will not let me go to the jail to have an in-person visit. I think Wake County is still doing video visits at the jail. And so that those things make it difficult for an attorney to be able to go through discovery if you're not sitting face to face. And I think it's still going to be some time before attorneys can feel safe and comfortable going and having face to face meetings. I actually did not realize it, but had one yesterday when I went to see a client in Wayne County. I was told it's going to be, and I thought that would be safer for both of us to have a visit where we're on the phone between glass. But instead, when I was there, they brought my client into the area. There was I did not see a single staff member or an inmate, including my client, have a mask on. I had a mask and gloves on, but that was concerning, not to see that at jail. And so I think there are still, it's going to take time for attorneys to feel comfortable in order to have the in-person visits. And again, some jails are not even allowing it right now. So I think number 11 is appropriate as written right now because it addresses the different health concerns and the preparation concerns. Thank you.
Thanks, sir.
Teresa, I would like to say as it relates to the proposal that was submitted by the Chief District Court judges. Not that I feel very strongly about it, but I do believe if you separate it out, it takes away the need for that communication. Sometimes our schedules, cross, and it's easier if you make arrangements for your level of court because you know when the needs you are, you know what you got going on, and if you don't have time or something happens in terms of your communication with the senior resident Superior Court judge, and that's not communicated properly, you could really end up in a pinch. And that I think that's a benefit of having it done separately. But like I said, I don't necessarily feel strongly about it, but I do think that's a benefit to having each, resident Superior Court judge and Chief District Court judge handle their own needs.
Okay, there was some of those comments I was unable to hear. That was Judge Vincent, right?
Yes.
Okay, Judge Vincent, and do I understand correctly that your preference would be to have a separate plan submitted on behalf of the district court, but that's not necessarily a strong preference? Was that the essence of what you said?
That is what I said. I said I think it's that way you don't have to worry about miscommunication or not being able to communicate because you have conflicting schedules.
Mm-hmm. Okay. All right. Judge Corpening, do you wish to provide any further comment that you received from the district court judges in that regard?
Yes, sir. Thank you, Judge Bridges. This is Jay Corpening. I'll just add that in my conversations with Judge Vincent and with some of my other colleagues, the bulk of these recommendations apply to all of us for any proceeding. But with respect to the early recommendations of the report, who the decision makers are about resumption of jury trials, because of the statutory obligation of chiefs to schedule civil matters, it seemed like we could create a dual track for approval. And our suggestion is that we include in our list of folks that would be consulted for district court jury trials, the COVID-19 coordinator, because that would be a necessity because the COVID-19 coordinator, whether it's a senior resident or designee, has to approve calendars right now. And then we would include more case type specific folks in that list. For example, our trial court administrator or TCC, family court administrator, if that's appropriate, domestic lawyer, civil lawyer. But to create actually two tracks for approval of that process. And that's our recommendation. The bulk of the report is fantastic, Judge Bridges. You've done a great job on that. It's just in those limited areas that I spoke with you about right before we got on the call today that were of concern.
We haven't heard anything from the civil practitioners bar. Do you all wish to weigh in on any aspect of this?
Judge, this is JD Keister. I think the plan laid out meets with what we were looking for. I think it's an excellent plan. And I did want to clarify, and I think I understood it in item number 6 through the use of either we have a lot of lawyers that are going to be handling cases in 12, 15, 20 different counties. You are intending through this recommendation that each county, each judge will have either local orders or administrative orders outlining what their specific plan is.
Yes, sir.
That makes sense to me. I think it looks good from the civil side of things.
Your Honor, John McCabe, I likewise feel very good about the proposal that we have.
All right, folks. What about the clerks? Have we satisfied the concerns of the clerks?
This is Marcia Johnson. Having reviewed all of the recommendations, all of our concerns have been addressed, and I think that it'll be fine with us.
Thank you, ma'am. Ms. Shingary?
Thank you. I concur and appreciate you allowing our input.
Thank you, ma'am. Is there anyone else? Kelly Meyer spoke from the standpoint of the court managers. Kinsley Craig, any further input from the court managers?
No, I agree completely with what Kelly has presented. So I have no further input at this point.
All right, then. I believe we have identified at least one area that needs to be that will require some edits, and that would be to create the dual tracks for plans from the Superior Court and the District Court. Is there anything else I'm overlooking that's going to require additional edits?
Your Honor, this is Wade Harrison. I was just looking at it. I think in number 4, paragraph 4, you may want to add the clerk there. I mean, I'm the chief district court judge there, because that deals with the threshold decision about when jury trials will resume.
Right, right. And indeed, it was my intention to have the chief district court judge there. So thank you for that, reminding me of that again.
Judge, this is Robert Evans. As a point of order, I'm assuming that we're going to potentially vote on this plan in short order.
I hope so.
Okay. And Billy, I'll let you weigh in as president of the conference. But I think it basically is an excellent plan. And I think that all of those who have contributed to it need to be congratulated. And you have my highest admiration. I do think that in number 11, it's just sufficient to say that the first trials that are set should be short and less demanding, and that they are expected to take less than a week to try, without the additional information concerning the class. My concern, Judge, is that I think it's important for us, and you've mentioned this before, to develop as much consensus on this before we submit it to the Chief Justice as possible. And given that concern, representing the conference, I would have to vote against the plan in its entirety just because of that one bit of language. Basically, what I would ask is that when that vote happens, if that no vote, and I'll let Billy talk about this too, could be cast as a vote to that specific item, as opposed to, in a footnote, as opposed to the DA's conference rejecting this plan in its entirety, which I would think all of my colleagues would find unreasonable.
Robert, this is Waylon Sermons. Would it suit you if we just left out the parentheses that had the Class H or I, Class B2 or higher? I mean, I know that we put them in there, but if you use your language, I think it tells us what we need to know, and would that suit you? Would that be all right?
I'll let Billy, it suits me if what you're saying is that basically we need to have short trials that last less than a week.
And don't try any complex civil cases or high-level felony cases. And just leave it, up to the discretion as to what a high-level felony case is. Because the cases will rise and fall on how many witnesses, how many evidence, how much stuff, that complicated embezzlement, that may.
As I've said before, Judge, we rely on on our judges to make those kinds of decisions. And so if you got a prosecutor who's going to come in after reading this and put a 3-week or 4-week first-degree murder case on the calendar, I would expect the judge to reject that. Because basically we're saying that at this point in time, given what we're facing, that's not a reasonable position for a prosecutor to take.
This is Patrick Weed. Again, like I mentioned earlier, I think, and I know perhaps there may be, on one side or the other, a vote or two that may need a footnote. But I believe from the feedback that I've received, I'm very comfortable with the way that number 11 is written right now. In parentheses, it says G. It's just about giving away an example. Doesn't mean that a class C could be tried. There's a class C embezzlement that should not be tried because it's looking at other language that it's complex and would take more than a week to try. It also, I think, has appropriate language of saying of the parties, which reflects some of the concerns Ms. Harjo has indicated. If everyone is ready to proceed and the case can be done safely, and it is high-level felony case that could be tried in 4 days, and both sides are ready to go, and both sides want to get it done. Perhaps a speedy trial motion has been filed, then this recommendation is not indicating that could not proceed as planned. I think that the way it's written now addresses all the concerns appropriately, and I ask that the language stay the same.
Mr. Weed, this is Don Bridges again, and I'll add this comment. After working through this draft with the Superior Court Judges Working Group, one of the members of our working group, one of our judges, made a specific comment saying that he interpreted this language to read in a way that in his district, he has already identified certain cases that when jury trials are allowed to resume, he has identified certain cases in his district in which both the prosecutor and the defense attorney have already agreed they are ready to proceed with murder cases, but those murder cases are something that are going to take less than a week to try. And it's consent by both sides. Both sides have said they're ready to go. They want to try the cases. And even though they're high-level felonies, he says they're relatively simple cases to try. Everybody knows what the evidence is and how it's going to pan out. It's just a question of putting it in front of a jury to decide the case. And we believe that those cases would qualify under this framework.
And I would agree. I think that the way it's worded right now permits assuming that of course that it's safe with consultation with the clerk and medical experts in the area. I think the way it's written right now permits exactly that.
At this point, we've had much discussion about it. I will entertain a motion as to how we should proceed at this time.
This is Patrick Weed. I would move to adopt the resumption of jury trial plan as written.
Judge Bridges.
We have a motion from Mr. Weed to adopt this plan as presently drafted. Mr. Weed, would that be with the changes noted by Judge Vincent and Judge Corpening about the parallel plan for district court?
Absolutely. I apologize. Yes, definitely.
Is there a second to that motion?
This is Wade Harrison. I second it.
We have a motion and a second. Is there any further discussion?
Yes, Judge Bridges, this is Kelly Myers.
Yes,
Just
ma'am.
for clarification, paragraph 3 under the recommendations says the task force does not consider remote jury trials to be a feasible option in North Carolina at this time. However, our safety recommendations throughout, although they do not necessarily say a remote jury trial in full, do recommend various portions of a jury trial, particularly in jury selection and voir dire, may be done remotely or by other means. And so I just asked that we make it clear in number 3, and I don't think we addressed whether or not the task force would be okay with making that change to number 3.
And the comments I see from Ms. Myers that she provided me in writing read, the best safety practice recommendations include a great deal of suggested remote practices leading up to the impaneling of the jury and actual trial. Online orientation video, remote pre-screening for deferrals, excusals, remote strikes for calls after answering questionnaire. Could this sentence be modified to distinguish between the processes involved in jury management, jury reporting, voir dire, and trial to ensure that some remote practices are encouraged? So that's what you're seeking.
Yes, sir. Just some clarification that number 3 does not mean that courts during the process of a jury trial cannot use some of the recommended remote processes in our recommendations.
This is Patrick Weed. I would amend my motion to include the language that Ms. Myers has suggested.
All right.
And I'll second that amendment.
All right. Thank you, John. Is there any further discussion? All right. There being no further discussion, I will call for a roll call vote, yes or no, upon adoption of the motion to approve this current draft of the plan for resumption of jury trials.
Judge Bridges,
I vote yes.
Judge Corpening,
I vote yes.
Judge Vincent,
I vote yes.
Judge Sermon,
Yes.
District Attorney West.
I think that representing the Conference of DA's position, we object to number 11 as written. We do not object to the rest of the proposal and document, but we request a footnote as to us objecting to number 11, and also ask to provide language that we think would be appropriate in number 11 as part of a footnote or addendum, or however the task force thinks it should be worded, addressed.
All right. Please proceed with the roll call vote.
District Attorney Evans, District Attorney Evans, can you hear us?
Yes, I vote no. Hello?
Clerk Johnson,
Yes.
Clerk Chingary,
I vote yes.
Kinsley Craig,
I vote yes.
Kelly Myers,
Yes.
Jennifer Harjo,
Yes.
Mr. McCabe,
Yes.
Mr. Harrison,
Yes.
Mr. Weed,
Yes.
and Mr. Keister.
I vote yes.
All right. Thank
That
you
is
very much. The
everyone
next
present.
question. I'm sorry.
You're
sorry.
fine. I was just relaying that was everyone present.
Okay. The next question I will pose to the task force, Mr. West and Mr. Evans have asked that they be allowed to include a footnote to explain their objection to the plan as drafted. Is that a reasonable request? Now, procedurally, I'm not sure if that's something that should have been addressed to ask Mr. Weed if he would agree to amend his motion to provide for that language, or if it needs to be taken by way of a second vote. What is the pleasure of the task force as to allowing a footnote to explain the objection by the district attorneys to those provisions? Is that a reasonable request? Do you all agree to that?
Your Honor, this is Wade Harris, and I seconded it, and I think it's appropriate. The objection is to that one section, and that Chief Justice would need to know that we've got unanimity except for that one little thing.
This is Patrick Weed. I agree. I think that part of what makes this document really good is how it shows reflects the different opinions. So I think a footnote is very appropriate.
Kelly Myers.
I'm sorry. Go ahead, Kelly.
I'm sorry. I was just going to agree. I think in a previous document in which we voted and I dissented on one singular point of the entire document, my explanation was included as a footnote in those recommendations. And so I think that the DAs should be permitted to give their explanation as well.
All right. Now, so that being the case, it would be my ruling as the presently presiding co-chair on this point that given the consent by Mr. Weed and Mr. Harrison to that amendment of their vote motion on which the vote has already been taken, unless Mr. Evans and or Mr. West wish to withdraw their votes, as I understood their explanations. Now, gentlemen, please correct me if I'm wrong, but my understanding is the district attorneys support this recommendation with the exception of those specific provisions. And so long as you're allowed to object to those specific provisions and explain the basis for that objection and a footnote to the report, if I understand correctly, you would change your vote and be in favor of passage of this motion. Am I correct in that regard?
That's correct.
Yes, sir.
Okay. That being the case, my ruling would be that the motion be deemed amended, that those votes are now in favor of the motion, subject to that amendment, with the additional provision that there will be a footnote added to explain the basis for that objection. The motion now passes unanimously by the task force. And thank you all very much. 2 weeks ago, I never would have dreamed that we would ever arrive at a unanimous agreement on a plan to resume jury trials in North Carolina, but we have now done so. And I thank you for your efforts. If we can agree on this, we ought to be able to agree on anything. But everybody's worked hard on this, and I want to thank each and every one of you for the expression of your opinions, your willingness to cooperate, your willingness to consider other points of view, and we have indeed made tremendous progress. Thank you very much. Okay, now I'll turn the podium back over to Judge Corpening this time.
So thank you, Judge Bridges, and thanks for all your work on this. For the rest of you, I'll just share with you that Judge Bridges has been tireless in his pursuit of consensus on this issue and working on this. So thank you, Judge Bridges. So we've got another item for suggested statutory or rule changes together with funding concerns. Judge Bridges, I'll just conference with you for just 1 minute. We've now been in this meeting for 2 hours and 11 minutes. Any thought about pushing this to our next meeting?
That would be fine with me. I know that folks are ready to move on to other things. I think we can address these points at our next meeting.
All right. Thank you, sir. And so this is Jay Corpney again. As part of discussion for our next meeting, we've got some suggested statutory or rule changes from our committees. So I'll ask the committees to be prepared maybe to discuss any statutory changes or rule changes that they're recommending at our next meeting. We have distributed as part of the materials for this meeting the response, the COVID-19 response and recovery expense estimates for AOC. We certainly have not been asked to make funding recommendations, and any recommendations we make would be to the Chief Justice. And so we'll engage in a discussion about that in our next meeting as well, in terms of whether we should make recommendations. And then if we do make recommendations, whether they need to be specific monetary recommendations or not. So with that, Judge Bridges, I'll pass it back to you.
All right. That brings us, thank you, Judge Corpening. That brings us to the final item on the agenda, which is simply goals for our next meeting and the proposed date and time for that meeting. I propose a date of 1 week from today, and personally, I would prefer a meeting time of 2 o'clock rather than 2:30, simply because we wind up potentially being very late in the day when we finish. Otherwise, as we've experienced today.
Don, this is Waylon. We have our conference next Thursday.
Oh my goodness.
I suggest we skip a week of this process, because you and I and Chuck will be in that conference WebEx. So how about the 25th?
What days are we in that, Waylon? I don't even remember.
Thursday all day.
Okay. How about if we move this up 1 day earlier in the week? Can we do it Wednesday instead of Thursday?
Is this really that pressing that we can't take a week off of this process? People are getting worn out.
I know.
We've gotten the resumption of jury trials passed, and I think this can wait till the 25th.
Okay.
Your Honor, this is Wade Harrison. I think we're in the short rows here. I think if we could meet, I don't even know that we'd need to meet for the whole 2 hours. If we could meet on Wednesday, I think we could knock out whatever needs to be decided about the final report and just send it on in.
The items I had on my list as goals for the next meeting would be to put a final stamp of approval, come back to you all with the absolute final draft of the plan for jury trials, which is simply going to be a few edits that you all already know what they are. So hopefully that will be a mere formality, I hope. Second, to talk in further detail about the possible statutory rule changes and any funding requests. That may be the thing that takes up the bulk of the meeting, and then finally to finalize our second report to the Chief Justice.
Judge Bridges, this is Kelly Myers. Are we under any type of time constraints to get our especially our statutory suggested changes to the AOC and to the General Assembly? And I just said that. So. Okay.
As I recall, our time constraints were June 15th for our first report that was approved at our last meeting and is in the process of being put together for delivery to the Chief Justice, and June 30th for the plan for resumption of jury trials. So we don't have an immediate time deadline, and you know, frankly, we could take a week off and come back, or we could take 10 days off and come back on Monday or Tuesday of next week. But let's just decide and wrap up today's meeting and then move on to whatever date the next meeting's going to be. Judge Corpening, what do you recommend?
I recommend we take next week off, and my preference would be Thursday of the next week at 2 o'clock. I'll also add real quickly that the Caring for You product produced by Jim Drennan's committee has now landed in the email inboxes of any state employee that's participating in the call. It's been distributed.
This is Judge Vincent. I would just like to throw this out there. I mean, I understand we have chosen Thursdays. It's really hard for me because I have a specialty court that I'm responsible for, and anybody that knows anything about those particular courts, it's detrimental to the clients when you substitute other judges because they thrive on consistency and stability. If Wednesday or another day would work, I would prefer that.
Judge Corpening, are you available as easily on Wednesday as you are on Thursday?
Yes, sir, I am.
Only make it Wednesday, 2 weeks from yesterday, 2 o'clock.
Judge Bridges, I would have to miss. I have federal court in Wilmington that afternoon, but I can catch up if I do have to miss. If that works for everybody else.
That's Mr. Weed, is that right?
Yes, I'm sorry. This is Patrick. Yeah.
Okay. All right. With regard to the final version of the plan for jury trial, Mr. Weed, I'll make sure you get that well in advance of that date so you can communicate back to us in advance. But I suggest let's meet. What day is that? That'd be Wednesday, June 24th at 2 p.m. Is that agreeable?
Yes.
Yes, sir.
That being the case,
Works fine with me.
Yes, sir.
that being the case, all right. Let's stand adjourned until Wednesday, June 24th at 2 p.m. Thank you all.
Thank you.
Thank you.
Take care.
Thanks, everyone.
Good job, Don. Waylon.
Thank you, Waylon.
See you, man.
All right, take care.
Bye.